any time, and I hope we don't need it. We welcome everyone to today's hearing on government litigation and opportunities for reform. I'll now recognize myself for an opening statement. Today's hearing will address various aspects of government litigation that we believe merits reform. Our House Judiciary Committee is charged with safeguarding Americans' most fundamental rights. And through that lens, today's hearing is going to primarily focus on three topics: civil asset forfeiture, sue and settle tactics, and settlement slush funds. In recent times, here's the problem. Civil asset forfeiture has become a device for unjustified governmental takings. Federal and state laws allow law enforcement agencies to take personal property through civil proceedings under certain circumstances. The standards for government taking of property vary from state to state and sometimes differ from federal standards. The problem today is that current federal standards for civil forfeiture invite abuse, in part because state agencies can skirt state-based forfeiture protections and rely on more relaxed federal law to confiscate property, and that results in innocent citizens losing their property that the government simply pockets. Reform to federal law is necessary to restore the original intent of the law because it's an important one and better protect citizens' property. On the second issue, another area of reform relates to the so-called sue and settle tactics. Sue and settle can occur where pro-regulatory plaintiffs and willing government agencies circumvent federal law, namely the Administrative Procedure Act, while rewarding special interests that they favor. When a pro-regulatory plaintiff sues and then settles with an agency in ways that require certain types of rulemaking, the result is the plaintiff and agency can avoid public scrutiny and congressional oversight of the agreed-to policy. So the sue and settle tactics also can bind federal agencies to rulemaking that extends from one administration to the next. With reforms, we can better guard against this tactic and return transparency, because that's what the American people want and deserve, and congressional oversight to the agency rulemaking. And finally, the third issue, in this hearing, we're going to provide the opportunity to examine the use of settlement slush funds. That's a phrase that's thrown around, but it refers to cases where defendants settle lawsuits with government agencies, but instead of the government directing all settlement funds to the U.S. Treasury or to the injured parties, agencies have this habit now, and agencies instead require defendants to give the money to politically favored special interests that are disconnected entirely from the litigation in many cases. And these types of slush funds directed to support pet projects go to obviously the pet projects of an administration. They can amount to a form of executive branch spending that's not approved or even reviewed by Congress. This circumvents congressional oversight and the resulting accountability of the executive branch. So here too, of course, we believe that reform is desperately needed. So Congress is considering proposed legislation to address concerns with all these issues. And these proposals include, for example, the FAIR Act, H.R. 1525, the Sunshine for Regulatory Decrees and Settlements Act of 2023, that's H.R. 3446, and the Stop Settlement Slush Funds Act of 2023, that's H.R. 788. Government's unwarranted taking of private property and the administrative state's litigation tactics to game the system on rulemaking or to direct funds to politically favored causes are highly problematic. And our deepest concern is that they're pretty clearly a violation of our constitutional order. So we're here today to gain a better understanding of these issues and how possible reforms will help restore confidence in our government. We were talking here just a moment ago that the people's faith in our institutions is at an all-time low, and we have to fix this because it's difficult to maintain a republic if the people lose faith in those institutions. So with that, I thank all of our witnesses who appeared to testify before us today, and I look forward to a robust discussion on these really important issues. And I now recognize our ranking member, Ms. Scanlon, for her opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses for joining us today. I am delighted to have the opportunity to hear from some of these witnesses because although I disagree strongly with the majority's conclusions with respect to the need to impose additional burdens upon the settlement of certain federal cases, I strongly agree that the abuse and injustices allowed by our federal civil forfeiture system stand in need of serious reform, and I'm heartened by the broad bipartisan support for the FAIR Act, which would do just that. My interest in this bill stems from over a decade of work in Philadelphia before coming to Congress, to reform Pennsylvania's civil forfeiture statute in many of the ways proposed by the FAIR Act. The Legal Services Pro Bono program that I led worked in conjunction with the Institute for Justice, which is represented here by Majority Witness Kirby West today, and under the guidance of Professor Lou Ruley at the University of Pennsylvania Law School, along with an army of volunteer law students and attorneys who were trained and donated their time to help dozens of low-income Philadelphians challenge the abuses of Philadelphia's civil forfeiture statute by local authorities who used it to seize the property of low-income residents, many of whom were innocent of any crime. One of our typical clients, whose case resulted in the Pennsylvania appellate courts changing the standard of proof needed to seize assets, was Elizabeth Young, an elderly Black Philadelphia homeowner. Ms. Young was a widow with health problems, living in a house she and her husband had purchased over 40 years previously. After her adult son, I think he was in his 50s, moved in with 2 of his children, he was arrested for selling small amounts of marijuana. Despite Ms. Young never having committed any wrongdoing and with no proof that she was aware of his activities, the government seized Ms. Young's home and her car, throwing this elderly woman in poor health onto the street with no way to travel to her medical appointments. For context, her car and home were worth less than $60,000, and her son had been arrested for selling a few bags of $20 worth of marijuana. After pro bono counsel took years of appeals that went all the way to the Pennsylvania Supreme Court, Ms. Young prevailed in a groundbreaking decision on the proper application of the excessive fines clause of the United States and Pennsylvania constitutions in civil forfeiture cases. This case was far from the exception to the rule. Civil asset forfeiture was initially adopted as a tool to improve law enforcement by allowing the seizure of assets allegedly connected to criminal activity. But over time, we've seen that civil asset forfeiture laws have, number one, shown no identifiable impact on public safety. Number two, have resulted in wrongful seizure of the personal property of persons innocent of crime. And number three, created perverse financial incentives for law enforcement agencies to seize money and property to bolster their budgets. While the proponents of civil forfeiture projected seizure of drugs, expensive cars, and other fruits of criminal enterprise, far more frequently, we saw seizures involving the cash, homes, or cars of persons of limited means who were often innocent relatives of someone suspected, but not necessarily even convicted of criminal activity. Unlike criminal asset forfeiture, federal civil asset forfeiture laws do not require the government to prove that the individual whose property is seized has committed a crime beyond a reasonable doubt or even by a preponderance of the evidence. And federal agencies have been empowered under an administrative process to decide these cases without any judicial oversight. Furthermore, the federal statute encourages state and local agencies to partner with federal law enforcement to seize assets that more protective state laws would prevent. This perversion of the laws has created persistent abuses of civil asset forfeiture that require urgent and meaningful reform. Fundamental fairness requires that Congress ensure that people are protected from wrongful seizure of their property, and we should create guardrails against the persistent abuse of civil forfeiture laws that have raised real constitutional concerns for individuals' due process rights protected under the Fifth Amendment. Chief among the many issues raised by the civil forfeiture process is that it is so complex and the standard of proof so overwhelmingly favors the government that low-income victims of this process are often unable to navigate it. They frequently lose their property, homes, or vehicles by default in the legal process, either because they don't understand the process at all or they can't afford a lawyer. In fact, the typical value of seized property is usually less than half the cost of retaining a lawyer. With minimal due process protections, without court supervision, without a right to counsel, civil forfeitures can often leave people who've never even been charged with a crime financially devastated, even homeless, and with little recourse. And most frequently, these perverse financial incentives and due process issues play out in low-income and minority communities. Congress has direct authority to address much-needed reforms here, and we need to act. That's why I've co-sponsored H.R. 1525, the FAIR Act. This would address the due process concerns raised by our civil asset forfeiture laws, including eliminating administrative forfeitures, so only federal courts can order a forfeiture, providing access to counsel for indigent civil defendants seeking the return of their property, and requiring federal forfeiture funds to be sent to the U.S. Treasury's general fund rather than deposited into funds that can only be used for law enforcement purposes. These sensible reforms have garnered bipartisan support. Unfortunately, today this hearing is conflating this real issue that has bipartisan support with a partisan anti-regulatory agenda. For decades, Republicans have made spurious allegations that the federal government is engaging in executive overreach by abusing the court system to enact regulatory policies that violate Congress's legislative and spending authority to justify an anti-regulatory agenda. Democrats, together with a broad coalition of environmental, public interest, labor, and civil rights groups, have consistently opposed these anti-regulatory measures, both because they're unwarranted and because they undermine agencies' ability to protect public health and safety. We've heard our colleagues on the other side conjure up dubious allegations to justify taking action against a practice they refer to as sue and settle, but there's no credible evidence to support these allegations. In fact, Republicans have also argued that settlement agreements with corporate violators in cases brought by the Department of Justice that include a donation requirement to a third-party group might help remedy the harm caused to the public. Both parties' presidential administrations, including the Trump administration, have settled what can be more accurately described as deadline lawsuits. Congress authorizes these private lawsuits to enforce federal law and require that agencies abide by the rulemaking timelines set by Congress. Settlements and consent decrees are often the most efficient means of resolving these cases because the federal government has no chance to prevail in court. Not to mention, they save taxpayer dollars by avoiding expensive and protracted litigation. These third-party donation requirements allow federal agencies to hold wrongdoers accountable more effectively. These funds are especially important in addressing systemic injustices that impact all of us, but may not have easily identifiable victims, like harms to public health, the environment, or customers patronizing our nation's financial systems. These measures are designed to gum up the regulatory process created by Congress, and if passed, would result in weakened protections for public health and safety. Nonetheless, I thank the chairman for devoting time to federal civil asset forfeiture reform, and I hope to work with you both on the FAIR Act and other bipartisan measures in the future. Thank you.
Thank you, Ms. Scanlon. I now recognize the ranking member of the...
Can I just do a UC?
Sure.
Sorry. At the outset, I'd seek unanimous consent to introduce to the record the following. The 2021 report prepared by the Institute for Justice entitled Frustrating, Corrupt, and Unfair, Civil Forfeiture in the Words of Its Victims. A written statement by Professor Lou Ruley of the University of Pennsylvania Law School dated June 6, 2023. A letter from a broad coalition of civil rights organizations ranging from the ACLU to the Goldwater Institute expressing support for the reforms in the FAIR Act, and 2 law review articles by Professor Ruley, one from 2021 entitled Prosecuting Civil Asset Forfeiture on Contingency Fees, and another from 2017 entitled Seizing Family Homes from the Innocent.
Without objection. Without objection. Gentlelady yields it back, and I recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the majority appears to have dusted off its old playbook from the Obama administration for today's hearing. Apparently, whenever there is a Democratic presidential administration, Republicans' go-to move is to waste the committee's time accusing the executive branch of overreaching its legal and constitutional authorities. The conspiracy theory du jour for our hearing is that federal agencies are, quote, colluding with liberal activist groups to abuse civil litigation in order to circumvent Congress's legislative authority. But despite many hearings over several Congresses, as well as a multi-year investigation, there is simply no credible evidence to support these allegations. Instead, today's hearing is simply a tired attempt by the majority to paint a constitutional veneer upon their unpopular anti-regulatory agenda, which includes enacting legislation that will undermine critical financial, environmental, health, and safety protections for the American public. Take, for example, H.R. 3446, the so-called Sunshine Bill. This legislation would create a gauntlet of burdensome and time-consuming procedures that would effectively stifle settlements and consent decrees that resolve what can best be described as routine deadline lawsuits. The issue in these cases is a simple one. A federal agency has failed to meet its statutory rulemaking deadline or other duty, and a private party files a lawsuit demanding that they follow the law. That's it. The majority likes to spin tales of nefarious motives and collusion with liberal groups, a premise that the Nonpartisan and Independent Government Accountability Office debunked years ago. These deadline lawsuits do not result in a particular rule or policy outcome, nor do they circumvent the normal rulemaking process established by Congress under the Administrative Procedure Act. They simply require federal agencies to do the job that Congress gave them. Paradoxically, then, instead of protecting its constitutional prerogatives, H.R. 3446 would thwart Congress's will by further slowing down the rulemaking process that it has mandated. Of course, for my Republican colleagues, that's not a bug in the legislation, but rather its primary feature. Similarly, committee Republicans have alleged that the Department of Justice is, quote, colluding with liberal activists by including third-party donations and settlement agreements with corporate wrongdoers whose actions have resulted in public harm. Republicans accuse DOJ of essentially creating a politically motivated slush fund, an outlandish argument based on the false premise that such settlements are illegitimate, a premise that both GAO and the Congressional Research Service have debunked. Nonetheless, the majority seeks to enact H.R. 788, the so-called slush fund bill, which would prevent DOJ settlements with corporate wrongdoers from including payments to third parties, primarily nonprofits and educational and community-based organizations that are best positioned to remedy societal harms caused by the defendant. This legislation would curtail DOJ's ability to enter settlements with third-party payments that would provide relief for systemic or diffuse harm caused to the public by illegal conduct. Were Congress to pass H.R. 788, it would be a gift to lawbreakers at the expense of families and communities suffering from injuries that cannot be addressed by direct restitution, such as civil rights violations, environmental justice harms, or harms caused by fraudulent lending practices. The one bright spot in today's hearing is the discussion of the need to reform federal civil asset forfeiture laws. Here I do believe that there are legitimate policy concerns that current federal civil asset forfeiture laws create a set of perverse financial incentives for federal agencies to pursue civil forfeiture in unmeritorious cases. Combined with the low standard of proof that the government must meet and the lack of due process protections, current federal civil asset forfeiture laws raise serious civil liberties and policy concerns. My concerns are further heightened by the evidence that the burdens of civil asset forfeiture laws fall disproportionately upon working people, particularly in communities of color who already have few financial resources upon which to draw. Given the bipartisan interest in this issue, I am deeply disappointed that committee Republicans have chosen to shoehorn into this anti-regulatory hearing what is an otherwise worthy discussion of civil asset forfeiture reform. Unlike the case with civil asset forfeitures, these anti-regulatory bills are solutions in search of a problem, designed to serve deep-pocketed corporate wrongdoers and those seeking to undermine environmental, consumer, workplace, and other protections. To be clear, where there is a legitimate issue to address, we are prepared to work with our Republican colleagues. I hope the majority takes up the Bipartisan Fair Act of 2023, introduced by our colleagues Jamie Raskin and Tim Walberg, to address the real problems presented by federal civil asset forfeiture laws. The anti-regulatory measures that form the bulk of today's discussion, however, do not address legitimate concerns and are a distraction from the important work we could accomplish together. I thank the chairman, and I yield back.
Without objection, all other opening statements will be included in the record. And we will now introduce today's witnesses, finally. Begin with Ms. Kirby West. Ms. West is an attorney for the Institute for Justice. She litigates cases involving the First Amendment, educational choice, and property rights. She received her law degree with honors from Harvard Law School and clerked for Judge Dennis Shedd on the Fourth Circuit Court of Appeals. Mr. Andrew Grossman is a partner at Baker Hostetler, LLP, where he leads the firm's appellate and major motions practice. He also serves as a senior legal fellow at the Buckeye Institute and is an adjunct scholar at the Cato Institute. He received his law degree from George Mason University, Antonin Scalia Law School, and clerked for Judge Edith Jones of the Fifth Circuit Court of Appeals. Mr. Hsu, John Hsu, is an attorney who focuses on constitutional law, administrative law, antitrust law, and securities and corporate law. He previously served in both the George H.W. Bush and the George W. Bush administrations and has written about the use of settlements in government litigation. And finally, Mr. Todd Phillips is the founder of Phillips Policy Consulting and is a fellow at the Roosevelt Institute. He previously served as the Director of Financial Regulation and Corporate Governance at the Center for American Progress and as an attorney advisor to the Administrative Conference of the United States. We welcome our witnesses and thank you for your patience and for appearing today. And we'll begin by swearing you in. So if you'd all rise and raise your right hand. Thank you. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Let the record reflect that the witnesses have answered in the affirmative. Please note, as you all know, I don't think this is your first rodeo for any of you, but your written testimonies will be entered into the record in their entirety, and so accordingly we ask you to summarize your testimony in 5 minutes. You'll see the clock there and the lights, and I think you know the process. Ms. West, we will begin with you.
Thank you, Mr. Chairman, and members of this committee for the opportunity to testify today. My name is Kirby Thomas West. I'm an attorney at the Institute for Justice. The Institute for Justice is a national, nonprofit, public interest law firm, and for more than 30 years, we've litigated cases on behalf of individuals and small businesses defending their constitutional rights, including cases challenging civil forfeiture. When the government charges you with a crime, you can rely on the guarantees of the Bill of Rights to know that you have a fair opportunity to fully contest the charges against you. And the protections of the Bill of Rights also ensure that you won't be punished unless the government can prove its case beyond a reasonable doubt. But when the government alleges that your property, your car, your cash, or even your home has been involved in some kind of wrongdoing, there's a trapdoor to the protections of the Bill of Rights. This trapdoor is civil forfeiture. To describe civil forfeiture is to discredit it. The government can seize and forfeit property that it believes is connected with a crime, regardless of whether it believes the property owner committed or was even involved in that crime. And throughout the forfeiture process, the deck is stacked in the government's favor. The property owner has no right to counsel. The government need only make its case by a preponderance of the evidence. And an innocent property owner bears the burden of proving their own innocence. And to make matters worse, most federal civil forfeitures never make their way to a real court. Instead, the entire process occurs within the agency that's attempting to forfeit the property in what's known as administrative forfeitures. By way of example, from 2000 to 2019, 93% of the DOJ's civil forfeitures were administrative forfeitures. This process is extremely complicated to navigate, as shown here in this infographic. It's full of stumbling blocks for property owners, any one of which will cause you to permanently lose your property. And that's these red triangles here. And civil forfeiture is not only unjust, it's ubiquitous. From 2000 to 2019, federal law enforcement agencies deposited $45.7 billion into federal forfeiture funds. The reason that civil forfeiture is so common is very simple. Law enforcement gets to keep the money. Federal law enforcement retains 100% of the proceeds of civil forfeitures, and state law enforcement can get back up to 80% of forfeiture proceeds as long as they partner with federal law enforcement in a process known as equitable sharing. Civil forfeiture also just doesn't work. Studies have shown that civil forfeiture has no meaningful impact on crime rates or drug use, and it may even reduce crime closure rates by diverting law enforcement time and resources. So that's the problem. Now, what can we do about it? There are 3 immediate reforms that would make a big difference. Number 1, end administrative forfeitures. Part of the genius of the constitutional system of separation of powers is that it's designed to ensure it takes an act of each of the 3 branches of government to deprive you of your life, your liberty, or your property. Congress has to act to pass a law, the executive branch has to act to enforce that law, and the judiciary acts to adjudicate each individual case. But administrative forfeitures cut the judiciary out of that process entirely. If someone's going to permanently lose their property, they should get to appear in a real court before a real Article III judge. Number 2, end the financial incentive for forfeiture. Law enforcement priorities should be driven by how they can best solve and prevent crime, not by budgetary concerns. Directing all of the proceeds of civil forfeiture to the general fund rather than to the seizing agencies would eliminate that incentive. And number 3, end equitable sharing. In recent years, many state governments have reformed their civil forfeiture laws, but their efforts are undermined by equitable sharing. Ending equitable sharing would close the loophole that allows state law enforcement to circumvent state laws. Each of these reforms would be accomplished if Congress passes the FAIR Act, a bill with a wide coalition of advocates outside of Congress and strong bipartisan support within Congress, including both the current and the former chair of this full committee. I urge Congress to take advantage of this opportunity to work together to address a serious, long-standing injustice. Thank you very much for the opportunity to testify.
Thank you, Ms. West. And Mr. Hsu, you may begin next if you're ready.
Thank you, Mr. Chairman. Madam Ranking Member, thank you very much. The issue of improper third-party settlement payments, it is a nonpartisan issue. And my goal here is to try and explain why it's important for the Congress to protect its very own Article I powers, and not just in the sense of the Appropriations Clause, but also in the sense of statutes that the Congress has passed, such as the Miscellaneous Receipts Act and the Anti-Deficiency Act. But the fact of the matter is that the H.R. 788, which would end this practice, it's actually pro-enforcement, pro-regulation against any kind of corporate wrongdoing. The reason is because, for example, under the Obama administration, when the Obama DOJ settled cases, mortgage fraud cases with the bulge bracket banks, they gave credits. They gave a two for $1 credit to organizations that provided these types of improper payments. And the fact of the matter is that the recovery in overall dollar amounts could have been higher, could have been sent to the victims, or could have been sent to the community. And so in this sense, certainly getting H.R. 788 is pro-law enforcement against corporate wrongdoing and pro-enforcement of the regulatory state. Second of all, I think it's well known that only this body, only Congress has the appropriations power. And there have been Supreme Court cases that have ruled that unless Congress specifically authorizes an expenditure, it can't happen. And the earliest case that I can think of is the Reside case from 1850. That's a long time. That's a heck of a precedent. It's never been challenged, and I don't think it'll ever be overturned, quite frankly. Another issue I think that would be important is the fact that there is a question of whether H.R. 788 would take away an enforcement tool from not only the Justice Department, but any executive branch agency, including, but not limited to, HUD, EPA, Department of Interior. Probably these four agencies are the ones that engage in improper third-party payments the most. But the fact of the matter is that H.R. 788 and or its predecessors would not take away the enforcement tool. The Justice Department can only enforce the law as it is written. And the fact of the matter is that making sure that the victims receive restitution, making sure that, for example, in the environmental context, that let's say, British Petroleum blows a deep water well in the Gulf, there's nothing preventing either the Justice Department or the Congress from requiring that British Petroleum compensate for that horrific incident. So the fact is that I think this Congress can do itself a lot of good by exercising and flexing its Article I authority. Your body is the body that's closest to the people. I mean, whether it's in Midtown Manhattan, El Paso, Atlanta, Delaware County, Louisiana, Modesto, Roseville, Wyoming, or Reed County, the fact of the matter is that this would apply equally to everybody. And, we have in the news today that later on this evening, former Governor Chris Christie is almost certainly going to announce he's running for President of the United States in New Hampshire. As is indicated in my written remarks, which is submitted for the record, Mr. Chairman, the fact of the matter is that Governor Christie, when he was the U.S. Attorney in New Jersey, as part of a settlement with Bristol Myers Squibb, he forced an improper third-party payment. he forced Bristol-Myers Squibb to pay $5 million to Seton Hall to fund a professorship. Now, it's just by coincidence that Seton Hall is Governor Christie's alma mater. It's just by coincidence that that kind of work would be a boost to his local political career in New Jersey. Governor Christie's behavior there ought to be shocking and disappointing to everybody in this room, regardless of whether in the majority or in the minority. So if you don't like what Governor Christie did, if you don't like what the Republican administrations have done with respect to improper third-party payments, the solution is statutorily for the Congress to exercise its authority, get rid of it, and bring us back to a constitutional state for enforcement. Thank you very much.
Thank you, Mr. Hsu. And Mr. Phillips, you may begin. We're going in reverse alphabetical order if anybody's confused. Sorry. Throw you off.
Chairman Johnson, Ranking Member Scanlon, Ranking Member Nadler, and members of the subcommittee, thank you for the opportunity to discuss the federal government's civil litigation practices and authorities. I'm Todd Phillips, principal with Phillips Policy Consulting. I previously served as an attorney advisor with the FDIC and Administrative Conference of the United States, and as counsel with what was then known as the House Oversight and Government Reform Committee. My statements are my own. My testimony today will focus on my concerns regarding two enforcement bills the Judiciary Committee is considering. I note at the outset that, as the Supreme Court explained in the case Heckler v. Cheney, an agency enforcement decision, quote, often involves a complicated balance of a number of factors which are peculiarly within its expertise, end quote. If enacted, these bills would prevent the agency officials who know individual cases inside and out from using their expert judgment and discretion to ensure that the government operates efficiently. In addition, my time as a congressional staffer taught me to be concerned about waste, fraud, and abuse within the government, and I'm concerned that enacting these bills could ultimately result in wasteful government spending. First, the Sunshine for Regulatory Degrees and Settlements Act would, if enacted, empower opponents of particular regulatory safeguards, both inside and outside the government, to perpetuate unlawful agency inaction. Congress frequently enacts statutory deadlines for agencies to complete new regulations, yet agencies often fail to complete rulemakings pursuant to those mandates. Failing to enact mandated regulations can leave financial markets, the environment, and workers subject to abuse. It also creates uncertainty for industry, which must incorporate the potential effects of possible agency decision-making into future plans. Often, these deadline lawsuits are harmed parties' only available recourse as agencies delay rulemakings by 9 years, 12 years, or longer. Importantly, deadline lawsuit settlement agreements have no bearing on the substance of the rules agencies complete. Several GAO studies have found that settlement terms merely establish schedules for issuing statutorily required rules. No reviewed settlements included terms that finalize the substantive outcome of the ultimate rules. Rather than encouraging the executive branch to comply with its legal requirements, this bill would impose duplicative, burdensome, and time-consuming hurdles, slowing down the rulemaking process and preventing federal law from being implemented. It would subject any regulatory settlement to a lengthy new notice and comment process, even though agencies are already required to engage in notice and comment. It would permit intervention by individuals who declare themselves affected by the regulatory action and include them in court-supervised settlement talks, even though individuals aggrieved by rules may challenge agencies' rulemaking procedures in pre-enforcement litigation. And ironically, this bill would make the reason deadline litigation is brought in the first case, delayed agency action, even worse. Rather than endeavoring to slow down necessary congressionally mandated rulemakings, Congress should determine why agencies violate its mandates in the first instance. Next, the Stop Settlement Slush Funds Act would place arbitrary limits on how federal agencies may enter into settlement agreements that arise from enforcement actions brought against companies that have violated federal laws. Its cumulative effect would be to deter agencies from the efficient resolution of civil complaints through settlement agreements. When government agencies litigate, all parties may find that settlement agreements are the most effective and efficient way of resolving the issues and of improving the lives of affected non-parties. Importantly, without the ability to enter into settlement agreements that provide remediation to impacted victims, there is no guarantee that defendants will agree to settle. Agencies may be forced to trial, wasting time, resources, and taxpayer dollars, and delaying timely provision of relief for victims, if victims receive any relief at all. In In sum, these bills are solutions in search of problems and, if enacted, could result in unnecessary government waste. They would prevent the agency officials who know individual cases inside and out from ensuring that the government operates as efficiently and effectively as possible. Congress should endeavor to conduct oversight rather than enact dictates that apply to every agency settlement. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Phillips. Mr. Grossman, you may begin.
Mr. Chairman, Ranking Member Scanlon, and members of the subcommittee, thank you for holding this hearing today and inviting me to testify. My testimony will address a litigation-based regulatory practice known as sue and settle. Sue and settle refers to collusion between agencies and outside groups to evade transparency and accountability mechanisms through friendly litigation and settlements. In most cases, agencies vigorously defend against claims seeking to compel agency action, but that's not always the case. Agencies and activist groups have learned over the past decade or so that litigation and settlements can be used to expedite and even short-circuit normal regulatory procedures. The way it works is that an activist group files a case seeking to compel an agency to take some action, such as promulgating a new regulation or undertaking environmental review that will delay permitting that the group opposes. Rather than fight the case, the agency agrees to a settlement or a consent decree that obligates it to take the requested action, often on a set timetable. The agency may even agree to bind itself to certain types of policy outcomes. For example, a consent decree might adopt a broader or more burdensome interpretation of a statute or regulation. The advantage to the agency is that a settlement or consent decree means that its hands are tied to carry out the policy that it favors. Collusive settlements, of course, are not a new thing. The Reagan administration entered office to find itself hemmed in by consent decrees that had traded away policymaking discretion and purported to lock in policies that the administration considered to be unlawful and unwise. What has changed since then is that the tactic has become routine. The use of sue and settle exploded during the Obama administration. Between 2008 and June of 2013, 14 of the 17 major non-discretionary rules issued by the EPA resulted from deadline lawsuits. Both environmental activists and regulators have learned that they can use settlements to push through controversial policies. The Trump administration, however, stopped sue and settle in its tracks. EPA Administrator Scott Pruitt instituted a policy that restricted the use of settlements and made sure that no settlement could go forward without hearing from all of the stakeholders, including states and including regulated parties. Now, that policy was revoked by the Biden administration. Over the past 2 years, EPA has agreed to more than 20 litigation settlements, nearly all of them with environmentalist groups. And it isn't just EPA. The Bureau of Land Management has entered a series of settlements with environmentalists that have shut down energy development on millions of acres of public lands. According to one of the environmentalist groups behind these lawsuits, the settlements, and I quote, entirely recast the federal government's obligation to consider the cumulative climate impacts of oil and gas leasing. The result of these settlements is a de facto moratorium, which is completely at odds with the pro-energy policies enacted by Congress. The problems with sue and settle are obvious. It allows agencies to evade accountability. In some cases, it cuts short ordinary rulemaking timelines, limiting public participation and leading to sloppy rulemaking. And worst of all, it can allow agencies to achieve policy outcomes that Congress has rejected. But Congress does have the power to enact reforms. It should ensure that settlements are open to public scrutiny, that stakeholders have a seat at the table, that senior agency officials are accountable, and that settlements do not compromise the rulemaking process. The Sunshine for Regulatory Decrees and Settlements Act does all of these things. Congress should also reconsider aspirational and unrealistic statutory deadlines and broad citizen suit provisions. Suing to compel an agency to act on a permit application is entirely different in kind from seeking to compel it to issue generally applicable regulations or to take action against third parties. Citizen suit provisions give private litigants control over actions and decisions that are committed to the executive branch by Article 2 of the Constitution. And we have seen that allowing private parties to force agency action through litigation leads to bad policy results. I thank the committee for its time and for inviting me today.
Thank you, Mr. Grossman. We will now proceed under the 5-minute rule with questions, and I recognize myself for 5 minutes. I want to thank you all again for being here today and for your patience. And as I mentioned in my opening statement, we're here to discuss the government's use of litigation and the ways that we, the Congress, can reclaim our Article I powers and fight back against the abuses of power by the executive branch. And Mr. Hsu, I love what you said about our opportunity here to, I think you said, flex our Article I authority. Hear us roar, my friend. I love it. I wanted to amen you when you said it. So I'm going to start with you on the topic of settlement slush funds. So Article I of the Constitution gives Congress the power of the purse, not the executive branch. As you said, this should be well understood by everybody. My understanding is that the typical policy for settlement agreements with the federal government is to deposit those funds into the Treasury or distribute them to victims of the alleged action by a defendant. However, as has been noted here, under the Obama administration, the federal government began the practice of diverting the settlement funds to politically favored third-party entities or programs that the administration supported, all while avoiding congressional oversight. The Trump administration rightfully did away with that practice, but within his first handful of months on the job, Attorney General Merrick Garland revived the use of settlement slush funds, presumably to reward politically expedient groups. So, Mr. Hsu, with that context in mind, can you provide us any specific examples of the federal government using these settlement slush funds in contravention of Article I authorities?
Thank you, Mr. Chairman. Yes, probably the most egregious was the mortgage fraud settlements with the bulge bracket banks, J.P. Morgan Chase, Bank of America, Citi, et cetera. But, Mr. Chairman, I would respectfully disagree with you on the issue that began with the Obama administration. As a matter of fact, under President Carter, his Justice Department had written a memo that stating that, that these third-party payments were not proper. And as I mentioned before, even under a Republican administration, the Bush administration, 43, when Chris Christie was a U.S. attorney, he engaged in this reprehensible behavior. So, and in fact, you mentioned General Garland rescinding General Sessions' order, and that's especially interesting because if it wasn't a big deal, as some people say, then why would he have to rescind it? He rescinded it because it was an important function for them, an important funder of their allied groups. And make no mistake, they go to allied groups, whether it was Chris Christie or whether it was Tony West, it's going to allied groups. And I would add that in General Garland's rescission memo, he actually, in my view, misstates the law. He had cited an OLC memo from 2020, and which in turn cited an OLC memo regarding the settlement in the Canadian softwood lumber case. And the reason that's important is because, number one, the 2020 memo to General Barr, it was merely a form and legality memo about the CFR. It was not analyzing whether the Miscellaneous Receipts Act actually requires prohibiting a third-party settlement. So that was sort of a misuse of that particular memo. The Canadian softwood lumber settlement, again, I believe General Garland misapplied that case. And the reason is because in that case, the United States was the defendant. The United States was not the plaintiff in that case. Canada, our allies to the north, they sued the United States because they were unhappy with timber imports. And so in that situation, the United States as the defendant agreed to fund certain escrow accounts, not as the plaintiff. And also, there was plenty of disclosure in that case because the USTR negotiated that. Unlike the mortgage cases or other cases where there was no disclosure at all. As a matter of fact, if it hadn't been for former Chairman Goodlatte and his hard work and his team's hard work, and of course, working together with, at that time, Congressman Nadler and his excellent staff, the fact of the matter is that information would not have come to light. And I would say, when people lobby before Congress, that has to be reported. That has to be disclosed. But if it hadn't been for Chairman Goodlatte and the work of the entire committee, the lobbying that was done to the DOJ, the fighting for the money and the distributions, that would have never come to light. it would have remained in the shadows, and Congress would not have been able to exercise either its oversight or its statement and account power. And so that's why I'm here, to help Congress flex its power.
You know too much and only got one question in, so I appreciate that. I'm out of time and will yield back, and I'll recognize the ranking member of the full committee, Mr. Nadler, for his questions.
Thank you. Excuse me. Thank you, Mr. Chairman. Mr. Phillips, under H.R. 3446, the Sunshine for Regulatory Decrees and Settlements Act, it appears that any private third party could weigh in on a proposed consent decree or settlement agreement pertaining to a regulatory action that affects the rights of private parties. What is the scope of entities that could intervene in a suit to enforce statutory rulemaking deadlines under this provision, and what impact would it have on the efficacy of the rulemaking process?
Thank you, Congressman. This provision provides that any person who believes that it's in their interest, quote, who would, quote, not be represented adequately by the existing parties to the action, end quote, should be permitted to intervene in the litigation where a settlement agreement is being considered. This provision is written unbelievably broad with little limitation. It is much broader than what is currently required under the Constitution for constitutional standing requirements, which requires parties to show that they were or will definitely be injured by the agency's action, that agency delay will cause injury, and that the harm would be redressed by a favorable outcome. And the end result of this is that it will end up delaying the rulemaking process. Agencies are already required to go through a, in my mind, very laborious notice and comment process in order to ensure that the public has the opportunity to comment by allowing any party under the sun to engage in these pre-settlement arbitration discussions to try to add additional provisions. It's just going to slow everything down in an already slow process.
Thank you, Mr. Phillips. Why is H.R. 788, the so-called slush funds bill, a solution in search of a problem?
Yes, thank you again, Congressman. This settlements bill aims to address, the settlements this bill aims to address are just not problematic. No one is forcing firms to enter into settlement agreements. No one is forcing them into settlements with third-party payments. They do so voluntarily because they think that settling is a better value for them than the alternative. They could certainly proceed to trial if they wanted to, but enacting this bill would create more problems by preventing parties from voluntarily settling. If you look at the settlements entered into after the 2007-08 financial crisis, banks entered into these settlement agreements largely because of some of these third-party payments. So JP Morgan Chase settled for $13 billion, $4 billion of which was going to go towards consumer relief. A good chunk of that money Chase was going to have to pay regardless because they were going to have to do mortgage modifications and things like that. And so reducing its actual settlement expenditures to roughly $10 billion. If this bill had been in place and JP Morgan Chase had been asked to settle with a $13 billion fine directly to Treasury, I'm really doubtful that they would have settled and would have instead gone to trial. And that would have forced the Department of Justice litigators to spend a lot of time and a lot of money preparing and defending their action. And it would have just been wasteful government spending as opposed to moving on to pursuing different and other wrongdoers.
Thank you. Ms. West, the Institute for Justice's 2020 report titled Policing for Profit states that the Department of Justice's equitable sharing program, quote, creates a giant loophole, close quote. What is this loophole, and can you explain how it allows state and local law enforcement agencies to circumvent civil forfeiture laws passed by the state legislatures? Your mic.
Sorry, thank you. So with equitable sharing, even in states that have passed reforms to their own civil forfeiture laws, state law enforcement, if they work with the federal agencies, they can still get back the proceeds of civil forfeiture. And one great example for that is in Missouri. The Missouri Constitution actually has an amendment that says all of the proceeds of forfeiture should be going to schools. But because Missouri state law enforcement can still take forfeitures and hand them over to the federal government through equitable sharing and then get kickbacks of up to 80% of the forfeitures, a 2019 investigation showed that only less than 2% of the forfeiture proceeds in Missouri were actually going to Missouri schools, as is mandated by the Missouri Constitution.
Thank you, Ms. West. My time has expired. I yield back.
Thank you. The gentleman yields back, and Chair recognizes Mr. Kiley for 5 minutes.
I yield my time to the Chair.
Thank you for yielding. I got to go back to Mr. Hsu because I had some more questions. So I mentioned a moment ago that I started tracking this during the Obama administration, but as you noted, it goes back at least to the Carter administration. So that was a little before my time. But what is your best guess? Well, let me say this. One study that I looked at said that only 1.4% of all settlement slush fund payments can be tracked. So that means 98.6% of the $668 million that was that this calculation was directed in ways that were undisclosed. So we have no oversight ability at all over that. What's your best guess for how much money has been diverted through the settlement slush funds? And I guess this could go back to the 70s, right?
We're talking in the tens of billions, Congressman.
With a B, billions.
B.
Wow. I had a list of some of the Obama administration examples of this, where settlements were directed funds to the groups like National Fish and Wildlife Foundation, National Community Reinvestment Coalition, National Urban League, National Council of La Raza. In your mind, what are some of the more egregious examples, or can you name some of the beneficiaries of these funds over the years?
Yes, certainly the ones that you mentioned were beneficiaries. There were also, even local to Washington, D.C., you know, there was the Voice group and the Metro IAF in Virginia. They actually, not only did they lobby the DOJ, they also lobbied Mark Warner to help them get these settlement funds. And, you know, it's not an accident that every single entity who received the largesse of improper third-party payments was a liberal group. Now, you could say, well, it's because the Obama administration is Democrat. Yes, I understand that. But there's also an email that former Chairman Goodlatte had uncovered, where you have the acting senior counsel for access to justice programs at DOJ writing to the principal deputy associate attorney general. And she said, concerns include, A, not allowing city to pick a statewide intermediary like the Pacific Legal Foundation because it does conservative property rights, free legal services. I mean, come on. And I'm not saying it's bad or good. You know, as I mentioned, Chris Christie was awfully partisan himself. So I'm saying that either way, from either point of view, it's not right. And it's offensive to Congress's power and authorities.
We agree. Ms. West, I want to go to you. I love your a picture's worth 1,000 words. I think there are actually 1,000 words on this chart here. And for those who might not have seen your opening testimony, this is in the record, but this is entitled The Convoluted Process Property Owners Face When Their Property is Seized for Federal Forfeiture. And it is there's no way that, I mean, I'm a lawyer and this is hard for me to follow. And so it's difficult for citizens to do that. It's difficult for us to track and oversight and all the things we're talking about. To summarize your testimony, you said, this is a trapdoor for the protections of the Bill of Rights, and you said you gave three recommendations: end administrative forfeitures, end financial incentive for forfeiture, which is send all this to the general fund instead of these other things, and then inequitable sharing. So real quick, with a minute, 90 seconds, if we were able, the FAIR Act has all this in it, if we were able to pass legislation to check each of those boxes, what would this chart look like after that? Would it simplify it dramatically?
Not only would it simplify it, it would take away this whole half of the chart.
Oh, wow, okay.
So anything under administrative forfeiture, if we end administrative forfeiture, all forfeitures will happen where they should happen, which is in a real court, a real Article III court.
Excellent. Mr. Grossman, you said that the sue and settle issue really exploded under the Obama administration. Do you have a theory as to why it began? Why is this such a recent advent in the law or a recent practice?
I think the political dynamics really do explain it. Many of the groups bringing these suits are pro-regulatory groups. They had discovered that they could use the leverage of litigation to lead to favorable settlements at the tail end of the Carter administration. There was a little bit of activity along these lines during the Clinton administration as well, but it was really during the Obama administration that it exploded across the board, not merely in the environmental space, but really affecting any number of different federal programs and agencies.
And it started a custom and practice, and the only way to reel that back in and change it, in our view, is if Congress acts and has to do this. So that's why we appreciate your testimony so much. I remember from law school the term vexatious litigation. It feels that way. It feels like that. The chair is out of time, and I recognize next Ms. Escobar, 5 minutes.
Thank you, Mr. Chairman, and thanks to our witnesses today. Mr. Phillips, I want to piggyback off of something that, off of Mr. Nadler's question. So, under H.R. 3446, if the regulatory action involved the Clean Air Act, for example, could a private third party include someone who breathes air?
Absolutely, Congresswoman. The provisions in that bill are just so broad, as I said, to be practically meaningless.
Thank you. Also, can you share with us what are some reasons why DOJ or another agency might want to enter into a settlement agreement that would provide for consumer relief provisions, such as payment to a local community nonprofit organization?
Sure. So going back to the large bank settlements, these institutions were bundling mortgage-backed securities in such a high rate that they needed as many mortgages as they could get, and that incentivized the creation of low-quality mortgages. They had no interaction with the mortgage holders. They were not the ones who were making the loans themselves, and so they would not be the direct and proximate cause of those consumers' harms. The reason that DOJ or other agencies would want to include some of these third-party agreements is so that the consumers who were hurt by the defendant's actions, even if they were not the direct and proximate cause, could still get some relief. It's complicated, it's difficult, it is not a good use of corporate resources to search for each and every harmed individual. What does make sense is doing some mortgage relief or to give a donation to a group that is able to do homeowner relief themselves and things like that, even if they aren't a part of the company.
Thank you so much. Can you also explain how consent decree practices have resulted in beneficial settlements for all parties, including corporations, and produced good pro-consumer outcomes?
Absolutely, Congresswoman. The laws that Congress has enacted frequently require agencies to write rules by a certain deadline, ensuring that consumers, financial markets, the environment, workers are protected. The consent decrees that these agencies enter into really just ensure that the rules Congress has mandated get put on the books. It is just the agencies effectuating Congress's law. It's nothing more. It ensures that corporations are benefited by. Corporations can plan for the future. When Congress says to an agency to write a law by X date, but the agency doesn't do it, it leaves corporations in the lurch. They want to be able to plan for the future and know what the law is. But when an agency waits 9 years, 10 years, I do financial regulation. There's right now a rule that we've been waiting on for 12 years. It means that corporations can't plan. They can't invest as they would like to because of the uncertainty.
Thank you so much. Mr. Chairman, I yield back.
Thank you. The gentlelady yields back. The chair recognizes Mr. McClintock for 5 minutes.
Thank you, Mr. Chairman. When we speak of threats to democracy, it seems to me the ultimate threat is a government that's detached from the will of the electorate. When we speak of independent bureaucracies, I think we have to ask the question, well, independent of whom? Well, obviously independent of the elected officials who are in turn elected by and answerable to the people. So we're talking about the separation of our democracy, the rule of the people, from the government that now is in effect running itself. It's also then operating not only outside the rule of democracy, the people, but it's also operating outside the bounds of the Constitution, which gives all legislative powers to the Congress of the United States. Under the separation of powers at the center of our constitutional architecture, Congress makes law but cannot enforce it. The president enforces law but cannot make it. And the executive authority the exclusive authority to adjudicate disputes that are arising under our laws belong to the judiciary. Now, Mr. Phillips just told us, well, there's no problem here. Nobody's forcing these settlements, but that's not the point. The point is these settlements are making laws quite independent from the elected representatives. It may even be in diametrical opposition to the policies of the elected president. That means our government has become a law unto itself. Mr. Grossman, am I correct that a bureaucracy needs only to collude with like-minded pressure groups in order to establish a new rule and enforceable law, even if it's at odds with the elected representatives of the people?
In some instances, agencies have in fact done that to adopt legal interpretations that have very serious consequences to regulated parties as well as the broader economy. Yes.
Isn't this a quintessential threat to democracy when laws are imposed not by the elected representatives of the people, but entirely contrary to their wishes as they express them through the vote?
Yes, I think that is exactly right. And I think you see that particularly, as you pointed out, in the what's known as the slush fund settlement context, because in that instance, the programs that are being created by these settlements, they may be well and good. Some people may look at them and say they are laudable and they lead to good public policy results. The problem is they were never enacted by Congress.
And therefore, you have a runaway bureaucracy completely detached from control by the electorate.
Exactly. Not only standing up its own programs with its own policy objectives, but then funding those programs independently of Congress. So there is no check and no oversight.
And by the way, if it accuses you of violating the law it is now made by itself, you're held to account in an administrative law court, are you not, run by that very same agency?
That is often the case, yes.
And then as we get into some of the other issues, if the agency's court finds you guilty of violating the agency's law, the agency gets to decide what to do with those funds that it has now collected from you without the process of due process of law or trial by juries. Is that correct?
In settlements, yes. I mean, the money can be directed to third parties. And so, when Congress typically enacts a fine, the money goes into the Treasury, and then it's subject to appropriations. But under these sorts of agreements, there isn't that type of democratic oversight.
Mr. Hsu, we had a California insurance commissioner many years ago who was forced to resign when he was found to be directing a settlement with insurance companies to contribute to an ad campaign that featured himself as he prepared to run for governor. Is that the kind of abuse we're talking about?
I mean, it certainly could be,
and by the way,
in any other context.
And he was a Republican, as you pointed out. Chris Christie directed funds from a settlement to his alma mater, a Republican. So isn't this something Democrats should be just as concerned about as Republicans?
Yes, Congressman. That's why I mentioned that, whether somebody's from Atlanta or Media or Thousand Oaks, the fact of the matter is that this is a nonpartisan issue. Democrats should be concerned. There's also the funding issue in the sense that, in 2011, Congress had cut certain grantees from the budget. President Obama signed it into law, but these settlements did an end run around the appropriations.
This frightens me because it is a brave new world that's replacing the constitutional republic that our founders envisioned. And I think our chance to set things right is quickly passing from our hands. So I think the proceedings today are extremely important. I know the authoritarian left applauds these developments because they believe the policy outcomes favor their goals. But they should beware of such powers because those powers, once summoned, are not easily contained and could one day be turned against them.
Yes, sir.
Back.
The gentleman yields back, and the chair recognizes the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. H.R. 788 and H.R. 3446, which we're discussing today, should not be joined with the civil asset forfeiture measure that we're also considering today because, H.R. 788 and 3446 are MAGA Republican anti-regulatory bills in search of a problem. So I don't think we're well served by looping in this forfeiture bill with those two corporate-loving bills. H.R. 3446, the so-called Sunshine Bill, would throw a monkey wrench into the rulemaking process by creating a gauntlet of burdensome and time-consuming procedures before allowing an agency to settle cases. It opens the door wide to dilatory tactics by corporate opponents of statutes like the Clean Air Act, and it would force expensive and time-consuming litigation at taxpayers' expense. H.R. 3446 also subverts the federal rules of civil procedure and the longstanding practice of judicial discretion. Under the federal rules, the courts are empowered to manage litigation and to consider equities in their decision-making, yet this bill would strip judges of that authority. H.R. 788 would be a gift to lawbreakers at the expense of families and communities suffering from injuries that cannot be addressed by direct restitution, such as civil rights violations, environmental justice harms, or harms caused by fraudulent lending practices. That bill would hamstring DOJ's ability to address, remedy, and deter systemic harm caused by unlawful conduct. Democrats are prepared to work with our Republican colleagues where there are legitimate issues to address, but the anti-regulatory measures that form the bulk of today's discussion are not based on legitimate concerns. Instead, they are a reaction to MAGA conspiracy theories and would cause immense harm to the public health and welfare if they were enacted. Now, Ms. West, according to your organization's October 2021 report, which compared to Philadelphians' overall respondents. Well, let me rephrase this. According to your organization's October 2021 report, quote, compared to Philadelphians' overall respondents in civil asset forfeiture cases were more often minority and low income, and that, in fact, 2/3 of the respondents were Black. Do you agree that civil asset forfeiture impacts low-income people and people of color disproportionately?
Yes, Representative Johnson. And the report you're talking about is the report that Ranking Member Scanlon mentioned earlier. And it did find that civil forfeiture disproportionately impacts low-income and minority communities. And we have dozens of examples showing that that's the case. One example from, Mr. Chairman, from your home state of Louisiana, we have a client named Kermit Warren who lost his job, unfortunately, in the COVID-19 pandemic. And he was going to use his life savings of $30,000 to buy a tow truck to start a new business. And so he traveled to Ohio to look at a truck. It turned out the truck didn't work for him, so he took his money and he was flying back to his home state of Louisiana.
He had cash money.
Cash money, that's right. And his money was seized at the airport just because it was a large sum of money, and federal law enforcement agencies can do that when they see large sums of money. Yes, sir.
Mm-hmm. Thank you. Mr. Phillips, why would H.R. 788's limitation on settlement agreements be harmful?
Absolutely. It would require companies and the government to potentially enter into protracted court cases. It would prohibit them from settling and using their resources to enact new policies, to bring about new enforcement actions. It would just hamstring the federal government from using their independent and expert judgment to figure out how to litigate the cases that they are tasked by the Constitution with litigating.
Thank you. I'm reaching the end of my time, so I'll yield what I have remaining back. Thank you, Mr. Chairman.
Thank you. The gentleman yields back, and the chair yields to recognizes Ms. Hagman for 5 minutes.
Thank you. Mr. Grossman, When Congress passes a law instructing an agency to act, in some cases special interest groups sue those agencies and then obtain consent decrees that override Congress by requiring agency rulemaking favorable to the special interest. Doing so can bind the agency in ways not intended by Congress and even in ways that then bind subsequent administrations. But there's also another problem associated with this particular paradigm known as the Equal Access to Justice Act. Have you ever heard of the EAJA?
Yes.
Can you briefly explain what the EAJA does?
Well, in general, a plaintiff's group that obtains such a result in a case would be a prevailing party and so would be able to recoup a large amount of its litigation costs, including attorney's fees.
Well, and that's if there's litigation, but they also, the agencies and the environmental groups can actually enter into a consent decree where the agency will agree to pay EAJA funds to particular environmental organizations. Is that right?
Yes.
So I'm going to read a bit of information to give the folks here a bit more background about how the EAJA has been abused over the years. Environmental litigation has become an expensive national policy issue that causes harmful gridlock for the federal agencies managing wildlife and public lands. At the center of the problem is the Equal Access to Justice Act, which permits the recovery of attorney's fees in lawsuits against the federal government. EAJA was enacted in 1980 to protect ordinary citizens and small business from government overreach and wrongdoing by giving them the means to pursue otherwise prohibitively expensive litigation. But over the years, EAJA has shifted from being a well-intentioned corrective measure to a powerful weapon for large, well-funded special interest nonprofit groups to continuously sue the government on environmental issues. Litigation against government agencies is virtually nonstop because these groups can recover substantial legal fees under EAJA even if they win only a small part of the case or settle out of court. Most of these lawsuits are settled out of court. And recently, I filed a bill to delist the grizzly bear. But one of the things that happened was that the Fish and Wildlife Service agreed in 2007 and again in 2017 that the grizzly bear had been fully recovered. Environmental groups sued, and eventually the Fish and Wildlife Service reached an agreement. When the environmental groups came back seeking funds, they sought almost $500 an hour in their legal fees, and ultimately $1.4 million under the Equal Access to Justice Act. Wouldn't you agree that that is another incentive or perverse incentive that has been created that needs to be fixed, that encourages these kinds of sue and settle tactics that you're describing?
It is a very unfortunate structure in that effectively it's a self-perpetuating, pro-regulatory, almost lobbying treadmill because groups sue agencies to compel agency action. If in many instances the agency will be favorable to what it is the group is asking for, and so they then get priority for their policy preferences, and at the same time, they obtain additional funds that they can use to promote further regulatory initiatives. It is a very unusual structure that you would have the government funding effectively a pro-regulatory force to force the government to undertake additional regulatory actions. It's not protecting people's rights against the government, it's expanding the government to exert more force in general.
Interestingly enough, I've had numerous opportunities to deal with EAJA as a trial attorney, and I have worked with a variety of organizations, private landowners, farmers, ranchers, irrigation districts, interest groups such as Farm Bureau, stock growers, and those kinds of things. What I have found is when I prevail against the federal government, it's very difficult for me to receive EAJA funds, and yet when environmental groups, again, may prevail on a technical matter, and the agencies will actually enter into consent decrees so that they can get the EAJA funds. Have you noticed a similar pattern in what you have reviewed?
It's simply another aspect of the collusion that is unfortunately prevalent in this space, and certainly something that I think demands Congress's attention.
Thank you, and I yield back.
Thank you. Gentlelady yields back. The chair recognizes the ranking member, Ms. Scanlon, for 5 minutes.
Thank you. At the outset of the hearing, I spoke about the work that the Institute for Justice did with Professor Rulli at Penn and many of my colleagues to study and challenge abuses in Philadelphia's civil forfeiture program. And I would urge my colleagues to review the report that we've already entered into the record, because it's really thorough and really paints a pretty damning portrait of what can happen with civil forfeiture programs. In that report, it described the courtroom where civil forfeiture cases were heard as a kangaroo court, where if someone failed to show up, they could get listed for a default judgment. If they did show up, the prosecutors would relist the case again and again and again, forcing people to come back to court, which is a problem if you're in minimum wage or other restricted job. And your report also talked about the fact that it disproportionately entangled members of disadvantaged communities who would have difficulty fighting back. Took an average of 9 months to get property back, as long as 3 years, sometimes 3, 4, 5 or more court appearances. And then the median value of items seized by law enforcement in any incident was only $1,300. But the median cost of hiring an attorney to fight forfeiture was $3,500. Given this disproportionate impact and the costs, is it fair to conclude that the absence of counsel or a right to counsel significantly impacts the ability of people to fight civil forfeiture?
Yes, Ranking Member Scanlon, that's absolutely true. And that's another, I mentioned 3 reforms that would be accomplished by the FAIR Act, but of course the FAIR Act also includes a right to counsel, and that's so crucial when you look again at how complicated this process is. And you were talking about how the process disproportionately impacts low-income and minority communities. The report you mentioned from Philadelphia also showed that people who have lower levels of education have much harder time getting their property back. And it's easy to see why that's the case, because it disproportionately impacts low-income communities at both ends of the forfeiture process. So on the front end, we'll have law enforcement who will frequently say, these are high crime areas. We think that there was a crime involved in this property because this is a high crime area. Well, people live in high crime areas, and often those people are low income. And then on the back end, once you're already into the forfeiture process, it's not hard to understand why, if you can't afford a lawyer, you're going to be much less likely to be able to get your property back.
Thanks. I mean, the report also talks about more than half of the people who ultimately lost their property were never charged with a crime. Can you talk a little bit about the impact that civil asset forfeiture has on individuals who aren't arrested or charged, and the innocent owner issues?
Sure. So as I mentioned earlier, under current federal law, it's up to an innocent owner to prove affirmatively their own innocence, which is a huge problem. And in this report that you were mentioned from Philadelphia, it actually showed only 1 in 4 were found guilty or pleaded guilty to a crime. But there are all kinds of circumstances in which innocent people find themselves caught up in this forfeiture process. We have one client, for example, from Rochester, New York. Her apartment was raided because her boyfriend was accused of selling drugs. And during that raid, the local police department seized $8,000 from our client. Ultimately, which is often not the case in forfeiture, but ultimately there was a criminal charge against her ex-boyfriend, but he was acquitted of the crime. And nevertheless, the local police department turned over her $8,000 to the DEA for forfeiture. And this was money that she was planning to use to upgrade her business, which is a mobile food cart, to a full food truck, and to support her grandnephew and herself. And we don't have time to get through even half of the stories of innocent people who find themselves in a similar situation.
Certainly one of the egregious cases that I know our Philadelphia colleagues dealt with was a kid whose piggy bank with his $91 in birthday money was seized, and it took months to get this back. The financial incentives for law enforcement to sweep up everything they could and keep it, essentially, really add a perverse incentive here. Can you talk about that a little bit?
Sure. Law enforcement will sometimes be honest, and they'll say, oh, the reason we need civil forfeiture is because we need the money. But of course, I don't know what exactly is the right level of funding for the various federal law enforcement agencies, but what I am 100% sure about is whose responsibility that is, and that's yours. The Constitution unequivocally grants to Congress only the power to raise revenues, and so it's not only a corruption of this constitutional power for executive branch law enforcement agencies to be raising revenue, but it's also distracting them from what they should be doing, which is solving crime and preventing crime.
Thank you. I yield back.
Thank you. The gentlelady yields back. Chair recognizes the gentleman from South Carolina, Mr. Fry, 5 minutes.
Thank you, Mr. Chairman. Thank you for having this hearing today. I actually did a lot of work on civil asset forfeiture when I was in the State House in South Carolina. You know, it was amazing to me, as divided as this place is, as divided as Columbia can be at times. The bill that we filed was sponsored by 80% of the entire House of Representatives. You had conservatives lined up with liberals that really understood that this was a problem and that we needed to fix it. Civil asset forfeiture has really become a device for unjustified government takings. It's violative, oftentimes, in my view, of the 4th, 5th, 8th, and 14th Amendments. The problem that I have is that it doesn't have to accompany a charge. It's a totally separate mechanism. There's no due process or very little. There's no judicial review or very little. Whether or not it's excessive or not, there's no real protection for the individual. And as you pointed out, you have to go through this entire labyrinth here as a layperson, as a litigant yourself, to establish your innocence and to get your item back. And it's never within a timely manner. You know, many people are unaware of how the government or legal system really works until they find themselves in this exact spot. And as Ms. Scanlon pointed out, it's actually really interesting because a lot of these crimes or a lot of these seizures are less than $1,000. In South Carolina, 55% are less than $1,000. Nobody is going to hire an attorney for that amount of money to go get their stuff back. They're just not going to do it. In instances within the district, since we were doing this, Miss Ella Bermel was a 72-year-old senior living in Conway, South Carolina. She owns a 1,000-square-foot home. She's had it for decades. She's not in the best neighborhood. And she did everything she could to get people off of her property when she was sleeping or at nighttime or when she was at work because they would sell drugs at the corner by her house. And she put up no trespassing signs. She talked to other people in the neighborhood. She talked to parents. She talked to kids. She talked to the police. She even trimmed her bushes so that police could have a better vantage point of what was going on. And the city of Conway seized her home. She had to fight to get that back. It's very similar to what Ms. Scanlon was talking about earlier. Brandy Cook dropped off a friend at a Myrtle Beach sports bar as a favor. Drug enforcement agents swarmed the car in the parking lot. Because she was a waitress and didn't have a bank account, she had roughly $5,000 in her possession. Because her friend was wanted and she was unaware, they seized her money too. And it took really a very long time to get that back. This isn't a debate in my mind about pro or anti-police, really. It's really about process, right? Civil forfeiture is kind of based on the in rem jurisdiction that you can go seize the item, that the item committed the crime. It's not in personam, of course, which would be against the owner itself. You know, you look at these, Mr. Chairman, briefly, I want to introduce into the record with unanimous consent an investigatory series in 2019 from the Greenville News in the Anderson Independent Mail called Taken, which talks about civil asset forfeiture in South Carolina.
Without objection.
And another one, too, an opinion article by Andrew Yates on why South Carolina must end its civil asset forfeitures.
Without objection.
In this series, which is a massive investigatory series by the news, in 3 years, law enforcement seized $17 million. 20% of people who lost their property were never charged with an actual crime. Another 20% were charged but not convicted. The average time between seizure and when the prosecutor filed an action was 304 days, and 55% of cash seizures were less than $1,000. The problems, as you highlighted, really are everywhere. It's a separation of powers issue. It's a burden of proof issue. It removes the impartiality. Agencies now have a financial incentive to go do this and continue to do it. It doesn't protect innocent owners. It's not worth the fight to go against the government on small sums, as has been outlined. And of course, it's violative possibly of the 4th, 5th, 8th, and 14th Amendments. And of course, the preponderance of the evidence standard. I mean, these are all problems. Ms. West, have you encountered similar instances representing people who've lost either property or cash through civil forfeiture?
Yes, thank you. More, again, than we could possibly cover, even if this hearing was 3 hours longer. But one that comes to mind, just because you were talking about how long this can take and how long people can be deprived of their property in the civil forfeiture process, is we had a client who was traveling near the border to visit family in Mexico, and he was driving his Ford F-250 pickup truck, and CBP stopped him, and he didn't have any weapons in the car, but what he did have, he has a licensed firearm back home, and what he did have were 5 lone bullets in a console in his car. And CBP took his car because he was transporting munitions of war across the border. And after his property was taken and put into the forfeiture process, he went 2 years without ever having an opportunity to even have a hearing to contest the forfeiture and try to get his truck back. And that's obviously a huge problem because we see all the time, we have clients who, if you don't live in a place that has reliable public transportation, for example, if your car is taken away, that means you can't get your kid to school, you can't get to the grocery store, you can't get to your job. So this is a really serious problem, and these procedural defects really impact real people's lives.
Thank you, Mr. Chairman. With that, I yield back.
Thank you. The gentleman yields back, and the chair recognizes the gentlelady from Texas, Ms. Jackson-Lee, for 5 minutes.
Let me thank the chair and the ranking member for a very important and constructive hearing. It is noteworthy, again, I guess I'm often to say this, that we have gone through these civil forfeiture legislation initiatives in the more than 2 decades that I've been here. And I'm reminded of Chairman Hyde, one of the issues that he was focused on, the late Chairman Hyde. And it seems that we have a space where we can find some enormously bipartisan issues, and to listen to an example of a senior citizen's house being taken because they can't stop drug activity on the corner, on the front yard, is egregious. And there are similar stories that you have spoken to, Ms. West. And so I'm going to pose my questions to you and Mr. Phillips on a different line of questioning. First, I'd like to say that we recognize that penalties, civil penalties, are part of the justice system in some way, and that the taking of things are clearly an aspect of that. We just had the Department of Justice in Houston on a settlement of dumping, egregious dumping in somebody else's neighborhood. It happens to be in the neighborhoods of minorities. And so clearly a tool could be used. If you travel miles in a truck to dump, there may be a basis that punishment is that your truck is gone. You may have rights to get it back, but you've been notified, there are signs, it's not a dumping place, you're dumping. And so I would offer to say that it is a tool, but it is a tool that must be contained. And there must be reasons. So let me just raise this point, and I think you have, this report in just this October 2021 report on civil forfeiture says that frustrating, corrupt, unfair civil forfeiture in the words of its victims. Can you speak to where that is, or civil asset forfeiture is frustrating, corrupt, and unfair? And let me pose my question to Mr. Phillips before you answer, and that is that we are also lumping together a number of legislative initiatives that are shocking to me. H.R. 3446, saying that there's collusion among agencies around regulations. H.R. 788 prevents the DOJ settlements with corporate wrongdoers from including payments to nonprofits. And then H.R. 788 would be a gift, would in essence be at the expense of families and communities suffering from injuries that cannot be addressed directly. So things that would help the American public. Let me go to Ms. West on the frustrating and corrupt and unfair of civil asset forfeiture programs.
Sure. Thank you, Representative Jackson-Lee. I would say, to your point about forfeiture being a tool, no one contests that if the government charges someone with a crime and convicts that person of a crime with all the protections that the criminal justice system grants to that person when they are charged with a crime, the government can then take the proceeds of that crime or property that's the fruits of that crime through criminal forfeiture. And no change to...
And I should have clarified, and thank you for doing that for me.
Yes, so that's
what happened to a dumping case, but go ahead, it would be a criminal.
That's exactly right. So criminal forfeiture is what allows the government to address property that's actually involved with a crime. But when you look at civil forfeiture, you're sweeping in all kinds of other property. A great example out of California recently, our clients Linda Martin and Reggie Wilder were saving money to buy a home, and they had $40,000 in cash in a safe deposit box. So you think, you can't get more safe than that. You've got your money in a safe deposit box at a private safe deposit box company. The FBI raided that business and took all of the property from all of the safe deposit boxes, including Linda and Reggie's money that they were saving to purchase a home. And when they got a notice about the FBI's intent to forfeit everybody's property in these safe deposit boxes, they couldn't even tell what crime it was alleged that their property had been involved in because there was a laundry list of possible crimes. So you're looking at a situation where you're facing this, Byzantine process to get your property back, and you don't even know what it is that you're contesting. So I would just say that, criminal forfeiture is where we should look when we're looking to take property that's actually been involved with a crime.
I thank you, and I'd ask the chairman to indulge for Mr. Phillips to be able to respond to that question that I posed.
I always indulge, Ms. Jackson-Lee. Go ahead.
And I thank you, and I think this is an important hearing on the aspects of dealing with the civil asset forfeiture. Thank you so very much. Ms. Phillips?
Yeah, thank you, Congresswoman. Thank you, Mr. Chairman. Really quickly, you asked what could improve these settlements. I would say don't throw the third-party agreements baby out with the bathwater. I think they can be very useful. As I said before, I think oversight is really important. One representative brought up earlier the Equal Access to Justice Act. And one of the things that Congress did recently was it required all agencies that engage in that pay out EJA fees, EJA awards, have to submit that to a database that's accessible to the public so the public can understand where this money is going. Through this database, we have learned that the vast majority of EJA fees go to Social Security awardees who have been wrongly denied. They had to hire a lawyer to appeal, and their lawyers got EJA fees, helping them get Social Security benefits. I imagine that Congress could do something similar with regards to these third-party settlements, just to ensure that there is that disclosure and oversight. Sunshine is the best disinfectant, and I imagine this is something that could potentially get bipartisan agreement.
Thank you. I yield back.
Thank you. The gentlelady yields back, and that concludes today's hearing. And I do sincerely want to thank the witnesses again for appearing today and giving us your insights on obviously a very important series of issues that we may actually find bipartisan agreement on. So we'll see. Wonders never cease. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And without objection, the hearing is adjourned.